Can you do what? Who are you?
Tiffany Peterson, she's supposed to represent me in my case.
I think she is representing you.
I have other lawyers I have to go to, and I've been here all this morning.
And so what would you like me to do?
Singing.
Well, I'm looking at you, but you mean call your case?
Yes, sir.
You have an attorney.
Yes, but
It would be unethical for me. It would be unethical for me to call the case when I know you have an attorney.
she's playing on another case.
You know what? You can go out there and tell Miss Bauer, go out there, tell Miss Bauer that you fired it. Then you come back in and you can represent yourself as soon as she lets me know. Court's going to stand in brief recess. I'll come out and deal with Ms. Rose and Mr. Ping. I will deal with you in a moment. You don't want to deal with me right this second. Court is stand in recess.
All rise.
This courtroom doesn't start with order. It starts with chaos. You can feel the tension just from how the defendant tries to speak without his attorney. The judge shuts it down fast. And honestly, that tells you exactly what kind of day this is going to be. You've got a man trying to outmaneuver the system and a judge who's not having it.
He has been contacting the victim. In this case, I'm also asking you to report his jail phone call privileges. He's called her 195 times.
What?
Yes. And
Did you say 195?
yes.
Oh.
And even one of the calls, he said, email the judge and the prosecutor and the lawyer. And that day we received the email from the victim.
Oh, that's a lie.
Stop.
That's a fucking lie.
Hey.
Oh, no, you're not going to say that here. Phone privileges are hereby ordered revoked. Defendant's bond is set at no bond.
I don't give a fuck.
Okay, he's now in contempt. That's 93. Anything else?
I think at this time, Your Honor.
Okay, I'm going to need an order. Contempt. You got 93 on that. His bond's been revoked. It's 0, and he's got a
195 calls. That's not a slip up. That's an obsession. And when the judge hears that number, the reaction is visceral. You don't often hear a courtroom explode like this. The moment he says, I don't give a F*******, that's not just contempt of court. That's contempt for the law.
When he was arraigned on June 13th, 2020, he called his friend, after he was told not to contact the victim, he called his friend to ask and gave the friend the victim's phone number and asked the friend to have the victim bond him out or to give him money to bond him out. So I'm concerned about the fact that he was ordered by the court not to contact the victim, and then he went ahead and did that prior to being bonded out on the 13th jail call. We had originally asked for a $250,000 bond in this case, and he was given only a $25,000 bond. So I am concerned about that.
What?
Yes.
Mr. Crater.
Madam Prosecutor said she sent me, and I'm sure she did, but I've not received the audio of the jail call, so I cannot respond what's in it, what's not in it. What I can tell the court is that
There were calls made to the victim.
I can't represent
Correctly.
that. I haven't heard them. I
guess I want to make sure I'm hearing what I think I'm hearing.
There were calls made to third party, telling the third party to contact the victim and giving the victim phone number to the third party. That was the same phone number in the police report.
Got it. Okay. Go ahead.
All right, so I cannot speak to the phone call because I've not heard the recording of it. What I can tell you is that I have yelled at my client, admonished my client, if that did happen, he's not to have any contact with the victim. He's not to contact her or have a third party contact her in any way or fashion.
Well, why did he do that in the first place?
I don't know if he did or he didn't. It's the first I've heard of it.
Go ahead. What?
He explained to me that he did make a call to his friend Ali to have funds released so he could be bonded out. That's what my client tells me. I don't have the jail costs.
So he's saying that he didn't have any contact with or direct anybody to have contact with the victim in this case? Is that what you're representing to the court?
If I could have a moment, Your Honor.
Yeah.
I'm sorry. Did you tell him to call the witness? Did you say that? Did you say that? So you did do that? Yes. Okay. Your Honor, after conversations with my client, he states to me that he did ask his friend to contact the complaining witness in order to release funds to have him bonded out, Your Honor. He understands that he shouldn't have done that. I've yelled at him about that. I've explained to him that he cannot have any contact with the victim.
And everyone in that room. Clip 3. What's wild is the defense starts denying it, then slowly admits he told a friend to call the victim. You can feel the judge trying to stay composed, but you also see the deeper issue. This isn't just about bond, it's about trust. And this defendant keeps breaking it.
He did not, on that jail call, from listening to Miss Blanche's details, tell her not to show up, tell her not to cooperate. So I would ask that he be allowed to remain out on bond, Your Honor. I hear you. I can't hear you. Sure. And he wanted me to continue to say that he is fully employed, has a job waiting for
I
him.
understand that, but he's given certain conditions regarding his bond and just willfully violates. Defendant's bond is modified. Defendant's remanded. Defendant's bond will be set in the amount of $100,000 cash share.
Thank you, Your Honor.
Oh, I'm sorry, Judge.
The moment the judge says $100,000 cash, you realize the leniency is over. This is what it looks like when the system decides someone has burned through all their chances.
For David's sake.
And my client's sake.
No, he would have been fine. You would have had problems. All right, bond will continue.
Thank you, Judge.
There is one
Okay.
issue.
Yes, sir.
Detective Luke obtained a search warrant for the defendant's DNA. They attempted to effectuate that in the jail. The defendant refused to comply and would not let the detectives take a buccal swab pursuant to that search warrant. They are present here today. I'd ask that either the court could order him or it could be effectuated up here. The best way to handle that, but they were running into issues with the inability to obtain his DNA.
Judge, I don't think the court needs to order it at that time. At this time, I've spoken with my client about it. He will provide his sample today pursuant to the search warrant.
He'll do it right now. You guys can go back there. You can do it. Let me know before I continue to respond on this case or have the 7th or the 9th as the day. I want to make sure that that has occurred.
Imagine getting a court-ordered DNA test and refusing it in jail. That level of defiance is wild. It's not just disrespectful, it's tactical, and it backfires hard. When you play games with procedure, the court plays harder.
And the only information, Your Honor, I have with regard to the bond violation was that he was taken into custody on an alleged no contact violation that occurred at his house, where my client advises that the complaining witness showed up. He asked to leave. The police got involved. He was taken into custody as a result. I don't know exactly how that all came about. I believe that some yelling occurred. The police were called. He was taken into custody as a result. Your Honor, he does reside in a home with where he lives without the complaining witness. He is asking for some consideration there. He understands that he's not to have any contact as far as I'm concerned. And as far as I know, he did not intend to have contact that day. She came over. It was inadvertent in that he now knows that he cannot have the contact. He does have a 3-year-old daughter. He shares custody with the child's mother.
Did you request a hearing on that? Because I had already, I think, addressed this.
I thought you may have
increased his bond at the last hearing.
That was our impression too. I don't have any additional information if there was additional violations or anything alleged. I don't see any anything in our file from community corrections indicating that there were additional violations. I was under the impression that this was addressed when Ms. Hughes handled it.
I thought it may have been too, Your Honor. I just saw that it was set for a bond violation hearing today as well, and I did want to put up a bond argument on behalf of my client. I would ask, he has been in jail for the last 9 days, Your Honor. I would ask for home confinement if the court would consider that. He knows he can't have contact with her. He didn't intend to that day, and he, for all intents and purposes, wants to keep that contact from happening.
Okay, having heard nothing different from the last time, there's nothing that's going to change the court's position in the bond in this case.
Okay.
This motion for bond reduction is denied. Bond will continue. Thank you.
Oh, Your Honor. Finally, I just real quickly, he is on a tether. I don't know that since he's in custody that's necessary. If we could at least have that taken off, or some consideration for that to be taken off of him.
We'll leave that to jail.
The jail.
He's now.
You're under the jail.
His lawyer says the victim showed up, like he had no control. But the judge sees through that instantly. It's a masterclass in legal accountability. Intent doesn't matter as much as impact, and his impact keeps landing him back in jail.
Status since August 12th, 2019. In one of the cases, it was his third failure to appear in a row on that file that bench warrant then issued, and then he just remained in the wind since 2019. In the other file, his failure to appear to his other warrant was actually for him to fail to appear for a violation of probation hearing. So this is not a person who does well out on bond. This is not a person who typically follows court orders, and absconding for multiple years with 2 warrants out for his arrest, he was in possession of a gun. So, Your Honor, at this time, I believe that reducing the bond even further would not be appropriate, especially given that.
Your Honor, if I may just briefly respond. With this case, there are 3 defendants. There was 1 gun allegedly in a vehicle. 3 people have all been charged with CCW. So possession at this point is just an allegation. And then further, Your Honor, if coming to court would be the issue, which I completely understand from what Ms. Hughes just placed on the record, I think a GPS tether would suffice in letting us know his whereabouts and that he would be here at court.
Well, at this point, we're set for next week. I'm going to deny the motion for bond reduction. I'll just keep it the same at this point. We can take a look at it depending on if there's something.
Thank you so much, Your Honor.
Thank you.
This is where your jaw drops. He's been skipping court since 2019. That's not just evasion. That's years of running from justice. The prosecution lays it out like a timeline of excuses, and the judge doesn't flinch.
And he does admit to both. He indicates he did violate the no contact order. I would like to give the court some background on that. However, the date that he violated the no contact order, he indicates that he received a text message from the complainant saying, "Come grab your stuff," from the home. He went to grab his items from the home, and an anonymous caller then contacted police indicating that he was present at the home. And so, yes, he did have contact. He did go to the home, and that is the circumstances surrounding that. With regards for the missed tests, he has simply put no excuses for those. We've discussed the nature of this case and how serious it is and that he does need to test. He will be testing in the future. He will not have any other issues with testing. He has indicated to me. Should he be released, he would reside in Belleville with his father and his stepmother. He will also be working with his father. They do fencing, installation, and repair. So he will have gainful employment as well as family support.
Not sure I'm going to need a response because the problem, I hear what you're saying, counsel. Problem is he was supposed to be testing. He's not. He's been missing his testing. And the other thing is that he is apprised at the time of arraignment that if he needed to get his items, then certainly he could do that by use of a civil standby, and he failed to take advantage of that and decided to engage in self-help. So his bond will not be reduced to what you're asking. I will set his bond at a $50,000. I'll give a 10% privilege on that. But
10%, 50,000, 10%, 5,000. Oh, there's okay.
He violated a no contact order and skipped drug tests, But the excuse? She texted me first. No, that's not how the law works. Civil standby exists for a reason. And the judge reminds him, court orders aren't suggestions.